Hello friends, I wish all my listeners a very happy Diwali. I wish that all of you are in good health. In continuation of our series on the income tax cases, today we will discuss a case which is based on the assessment of the assessee under section 153A on the basis of the assessee name in the panchnama drawn in the search of some another assessee. This typical issue has been taken up by the Punjab and Haryana High Court in the case of MISTY, MEADOWS Private Limited versus Union of India and others. And this case has been reported in 465 ITR at page number 630. And the matter has been decided by Punjab and Haryana High Court on 13th May 2024. The case of the facts are very interesting and a little bit typical also. In the present case, there was already a search on the assessee, and in consequence to that search, the assessment under section 153A was done for the assessee for the assessment year 6-7 to assessment year 12-13. After that, another search was made on an assessee, that is M3M, and in that search, when the panchnama was being drawn, the name of the assessee was there and some incriminating document was also found to the assessee in the search of M3M, which were mentioned in the panchnama drawn. On the basis of that panchnama, a notice under section 153A was again sent to the assessee for the assessment year 11-12, and the assessment under section 153A was completed. The assessee raised the objections, and when these objections was raised, the objections were not entertained by the assessing officer, were not accepted by the assessing officer, and the assessment was made. The assessee went into the appeal of that assessment order because some additions were being made, and even after filing the appeal before the CIT appeal, the assessee preferred a writ petition in the writ court. The revenue came up very heavily that the assessee has already filed an appeal with the CIT appeal, so the writ petition of the assessee is not maintainable. But the Punjab and Haryana High Court on that issue said that since the appellate authority is not empowered to test the validity of a search, so the assessee writ petition can be entertained. The Punjab and Haryana High Court in the present case said that since there was no search warrant in the name of the assessee, and since because the name of the assessee is there in the panchnama, it doesn't mean that the revenue can complete the assessment of the assessee under section 153A. If the revenue wants to make the assessment of the assessee in pursuance of the name of the assessee in the panchnama drawn in the search of another assessee, then the revenue can do so only under section 153C and not section 153A. The Punjab and Haryana High Court also defined the panchnama and said that the panchnama has not been defined in the act, and the panchnama is a document which is prepared in the ordinary course at the site of an incident. The court said that when the search is carried out, then at that time there are two punches which are the local respectable inhabitants, before which the proceedings of the search are recorded, and whatever the punches see and hear at the time of the search, that is recorded in the panchnama. Panchnama is stated to be a memorandum of what happens in the presence of punches as seen by them and what they hear, and panchnama is a document which has to be prepared recording articles and materials and objects which are seized as incriminating material during the search. The Punjab and Haryana High Court said that in the present case, since the search warrant has not been issued in the name of the assessee and only because his name is there in the panchnama, the notice under section 153A cannot be sent to the assessee and the assessment is void ab initio, because the very basis of issuing the notice under section 153A is not there, because there was no search at all on the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is MISTY MEADOWS Private Limited versus Union of India and others, and this case has been reported in 465 ITR at page number 630, and the matter has been decided by Punjab and Haryana High Court on 13th May 2024. Thank you, friends.